Hello and welcome to another lecture of the Law of the Sea. I am Muhammad Tahmidul Islam, lecturer, Department of Law, World University of Bangladesh, and this lecture has been produced as part of the online learning system of the Department of Law, World University of Bangladesh. So now we are going to talk about archipelagic waters. Introduction. An archipelago, sometimes called an island group or island chain, is a chain, cluster, or collection of islands, or sometimes a sea containing a small number of scattered islands. Indonesia, Andaman and Nicobar Islands, Japan, the Philippines, Maldives are all examples of well-known archipelagos. So here I have attached a photo of parts of the Indonesian archipelagos. So here we can see that there are a few scattered islands here and there, and in between those islands we see the international seawater. So these are all saltwater areas. Article 46.1 of the 1982 United Nations Convention on the Law of the Sea defines the archipelagic state as a state constituted wholly or one or more archipelagos by one or more archipelagos and may include other islands. So archipelagic states are those states that have a lot of archipelagic island states. The new regime adopted by the United Nations Convention on the Law of the Sea guarantees the archipelagic state an impressive expansion in its maritime areas. In addition to its rights to the territorial sea, the adjacent area, the exclusive economic zone, and the continental shelf, as in other maritime states, it also exercises sovereignty over waters within the archipelagos, baselines that determine the maritime extensions of the archipelagic state, called archipelagic waters. So in the archipelagic state, we will see that they have the power to extend their maritime jurisdiction towards a certain area, and that area is called archipelagic waters. If the country is an archipelago or has an archipelago under it, a baseline is drawn between the outermost point of the island, provided that those islands are close to each other. All waters inside that is called archipelagic waters. So, if you look at island groups, we will see that how they draw their sea boundaries. They draw the sea boundaries from the outermost point of their island, which is the low water tide point, and then they draw a line between one point to another point, and inside that point all the waters are called archipelagic waters. The state has full sovereignty over these waters, very much similar to the internal waters, and the foreign vessels are allowed for innocent passage through archipelagic waters. So archipelagic waters are sort of like territorial waters. The foreign vessels can go through, but it should be innocent. The situation of archipelago states has been raised since the 1920s, when intensive discussions were held in various scientific societies concerned with the study of international law on the question of the territorial waters of the island. So, islandic waters are unique type, and their rights and liabilities are unique and special characteristics that should have special laws for themselves. So that is why archipelagic waters have been given a special place in the Law of the Sea Convention. The International Court of Justice, in its famous judgment in the fisheries case between Britain and Norway in 1951, addressed the issue of coastal archipelago states with regard to the drawing of the baseline from which the territorial sea would be measured in such cases. So with regard to archipelagic water, we will see that there has been a few cases. One of the most prominent cases is Britain and Norway, which happened in 1951, where the International Court of Justice, or ICJ, decided on a fact regarding archipelagic waters. Some archipelagic states have attempted to invoke the judgment of the International Court of Justice in the case of fisheries and to consider the waters between their islands as internal waters, although the distances of these islands are far apart. So, some archipelagic states contend that the waters or the sea area within the external points between those islands are internal waters and no other ship can get inside it. But this is not the general principle of law. The general principle of law says that archipelagic waters are just like territorial waters. The sovereignty of the state over its archipelagic waters extends to the airspace above archipelagic waters as well as to its water and subsoil and to its living resources. So, uh, unlike the territorial waters, no, actually, like the territorial waters, archipelagic waters also have airspace rights. So, we see that territorial waters, no other airplanes of any other country can go there without the permission of the coastal state. Just like that, archipelagic state has the power to authorize the airspace to other airplanes from another country. So this is actually the lecture on the archipelagic waters. Archipelagic waters are a unique type of waterway which are very similar to the territorial waters of a country. Some states believe that archipelagic waters are their internal waters, but it is not. It is not true. Actually, the Law of the Sea Convention says that archipelagic waters are unique, but they have the same rights and liabilities just like territorial waters. So this is the lecture content. I hope you have understood the lecture contents, and if you face any problem understanding the lecture, kindly inform me through your comment section and I will answer accordingly. Thank you so much.